Your Honor, opposing counsel, members of the jury, may it please the court. Deceit, disregard, and a dangerous combination. When my co-counsel, Rabab Kamar, came before you at the beginning of today's trial, she asked that you keep these three concepts in mind, for they are the foundation on which the defense's case rests today. There is no doubt that what occurred on August 18, 2010 is anything short of a tragedy. A young life was lost far too soon. We, the defense, offer our deepest and most sincere condolences to the parents of the deceased. But members of the jury, it is important not to mix fact with emotion. Plaintiff counsel is bringing forth a slate of intentional shooting in court today. They had to prove to you, per Midland Civil Code 2.01, that Jesse acted with intent, that Jesse either acted with purpose or knowledge. Now, I'd like to break this down a little bit using the facts and evidence you have heard in today's case. Opposing counsel offered no testimony today that Jesse had a complete understanding of how a revolver operated. You'll notice during deliberations a piece of evidence that was submitted, a search history on how to load a revolver. Members of the jury, Jesse's only experience with regard to firearms comes from a virtual world or a plastic, Nerf, or water gun. Members of the jury, plaintiff counsel failed to bring any experts to the stand correlating violence in video games with aggressive behavior. Members of the jury, Hayden Duran simply purchased games to entertain her child. Now, Jesse certainly had a passion for guns. Jesse certainly had an interest in the military, but members of the jury, that does not correlate to knowledge. A plastic video game controller is in no way the same as loading a metal revolver. The plaintiff counsel also had to prove purpose. They had to show you that Jesse acted with willful conduct, that Jesse wanted to shoot Sydney Park. Members of the jury, there is no question that what Jesse did was reckless. It might have been negligent. But members of the jury, when Jesse took the gun from Sydney Park, Jesse was not willful. Now, plaintiff counsel, as the party bringing forth the charge in today's case, had to show you their side of the story through what is called the preponderance of the evidence. They had to show you, members of the jury, it was more likely than not that what they attest occurred. We, the defense, were confident that plaintiff counsel would be unable to meet their burden. So much so that we have taken on a burden of our own. We are here to prove to you that intervening and superseding actions caused the death of Sydney Park on August 18, 2010. Now, I'd like to talk to you a little bit about Midland's case law that breaks down some of the elements of intervening and superseding causation. Blue Bond Records v. Sidocum Talent Agency breaks it down into three elements. The first is that a superseding element is sufficient to cause harm. Members of the jury, we know how Sydney Park passed on August 18th. Plaintiff's witness, Sebastian, took the stand and told us that during the autopsy it was revealed to be a massive head trauma caused by a bullet. Members of the jury, Jessie, when she took the stand, told us she had no knowledge that the bullet was in the gun. She told us that she wanted to reenact a game played by her and Sydney. Members of the jury, per the case law, the sufficient element that caused harm was the bullet in the gun. Simply put, a gun without a bullet is nothing more than a paperweight. It cannot cause harm to another individual. The second element, per the case law, is that it was not foreseeable to the defendant itself. Members of the jury, we have heard multiple witnesses testify today that they do not know how the bullet got in the gun. Jessie specifically stated that she did not know it was in there. When she originally opened it, before handing it to Sydney once again, nothing was in the chamber. Members of the jury, when they played their game of roulette, Jessie could not foresee what would happen when she pulled the trigger. And finally, the third element, that it was not the direct result of the defendant's wrongful misconduct. Defense is not alleging that Jessie was innocent on August 18th. Jessie pointed a gun at Sydney Park, which in itself can be reckless. But because opposing counsel brought forth the tort of intentional shooting, they have to prove that Jessie's actions were willful. Jessie did not put the bullet in the gun. Officer Williams took the stand and told us that he found the bullets on top of the safe. But plaintiff witness Andy Park swore that she kept them in the garage. No witness can testify here today and tell us specifically where the bullets were or how they had been moved. Opposing counsel at the beginning of today's trial mentioned something very interesting, and I actually wrote it down. They stated that virtual killings can turn into real ones. Defense has to disagree. A virtual killing in a video game is a computer simulation. There's a do-over. There's a reset. A child playing a video game has no full understanding of the consequences of what occurs when they press the button. For members of the jury, Jessie could not have understood fully what would have happened when she pulled the trigger on August 18th. She could not foresee what was going to occur because she did not know a bullet was in the gun. The two were 11-year-old children. The pair enjoyed playing video games. Sydney enjoyed playing them as much as Jessie Duran did. Members of the jury, there was not enough in court here today to tell us that Jessie acted with purpose or had knowledge of what would have occurred. Please, find our defendant, Peyton Duran, not liable of the actions Jessie took on August 18th. Because Jessie did not intentionally shoot Sydney Park. Thank you.